You gotta forgive me, I've never been a moderator. I've never been allowed up here. I think it's because they're afraid they'll never get me off. I was supposed to, which you probably all realize is probably true after yesterday, Friday. So I was supposed to announce beforehand that Marjorie's talk on PTSD, she mentioned that she had a questionnaire that we could pick up, and she said there were some issues. Elise has it now at the front, so feel free to pick that up. And so I guess this morning we'll get started. I'm going to do the, I'm going to present our panel. And so today we have, we're going to be having our MAID presentation. And our speakers, I have the top speaker I have here is Vanessa Gruben. I'm going to assume that's you, since I know the other two and they're not Vanessa's. So that's my reasoning skills. Vanessa Gruben is, has her BSCH from Queens and an LLB from Ottawa and an LLM, we're not sure what those acronyms are, from Columbia. She is an associate professor at the University of Ottawa, Faculty of Common Law, and a member of the Centre of Health Law, Policy and Ethics. She is a co-editor of the 5th edition of Canada's leading text on health law and policy in Canada, Canadian Health Law and Policy, co-edited with Joanna Erdman and Erin Nelson. Her most recent books are Surrogacy in Canada, Critical Perspectives in Law and Policy, co-edited with Alan Catapan and Angela Cameron, and Controversies in the Common Law, Tracing the Contributions of Chief Justice McLaughlin. That's forthcoming in 2019. That was co-edited with Graham MAID and Owen Rees. Professor Gruben teaches graduate and undergraduate courses in health law, public health law, as well as a seminar on access to health care. She's also a member of the Health Professions and Appeals Review Board and the Health Services Appeal and Review Board. I won't bother giving myself an introduction, I'm just the moderator. I can speak and I can read, and so I got the job descriptions covered. Marjorie, oh, have you written something in there I'm supposed to write?
So when I asked Rachael to do this, it was going to be Thursday night that we were going to start, but because of scheduling, it had to be Sunday morning. So I get this email from her saying, so what exactly is it that you want me to do? Because I don't really know anything about this topic, but if you want me to just randomly talk and fill in the time, I can do that totally really well.
Yeah. I need to read the crowd, be a bodyguard, like if we get a little bit out of hand, I can handle that. And although I don't know what time this is supposed to go to, so the time part I might actually not be very good at. So Marjorie Docherty hails from Kelowna, BC, where she has been a family physician for more than 30 years. She's originally from Scotland, as all of you will know the instant she opens her mouth. Her special interests have been behavioral medicine, medical ethics, medical education, obstetrics, and women's health in general. She served for over 10 years on the board of the College of Physicians and Surgeons in BC. And she served for 2 years as president of the board and spent several years on the ethics committee. During her time on the ethics committee, the Canadian guidelines were developed for medical assistance in dying, and she was involved in writing the guidelines for British Columbia. She's passionate about patient-centered care and is involved in undergraduate and postgraduate education as a faculty member at UBC. She has the academic standing of clinical professor and has had several teaching awards and family practice awards. She enjoys working with her patients through the cycle of life, both bringing life into the world and helping bring comfort to those departing it. She loves most outdoor pursuits other than mosquitoes and is married with three children and still has one, Daft. It doesn't say anything. I thought it almost said husband, but it does actually say dog. And I will warn you, don't sit beside her because you will have some psychopathology when you're done. Because she diagnoses you. And finally, Dr. Knight. He has worked as a GPO in medical oncology and hematology at the Northeast Cancer Centre in Sudbury since 1996. He was instrumental in establishing an inpatient and palliative care service and currently is the palliative care lead at Health Sciences North. Dr. Knight is the OPCN, which is the Ontario Palliative Care Network medical co-lead for Northeastern Ontario. And he is an assistant professor at the Northern Ontario School of Medicine, co-chair for the NOSM Palliative Care Education Committee, and a LEAP workshop facilitator. He balances his work life by cycling, cross-country skiing, and cottaging on Georgian Bay, and we're glad he could take time off those pursuits to come and join us today.
Thank you very much. So in terms of this morning's panel, I think what we'll do is I've been asked to speak for about 40 minutes. I'm not sure I'll even speak for that long. Just to give a sense of the legal frameworks that apply when thinking about medical aid in dying, medical assistance in dying, and talk about some of the upcoming legal cases that are on the horizon. And I'm really delighted to be here this morning to speak about this important topic. So in terms of a bit of a roadmap for this morning, I'm going to start by giving just a brief history of the current legislative framework. I think there are important lessons to learn from where we've been in terms of where we might be going with respect to the legal rules around MAID. I'm going to talk a little bit about conscientious objection and effective referral, and that's going to be pretty Ontario-focused because we've had some cases in Ontario about that effective referral policy. And then I'm going to talk a little bit about the grievous and irremediable condition requirement and how that's been interpreted. Again, there's a case in Ontario that sheds a bit of light on that standard, so I'll speak briefly about that this morning. Here we go. Oh, so in terms of my disclosures, I have none. Being a lawyer, no pharmaceutical companies really want anything to do with me. They avoid me like the plague. Okay, so where have we been? So as we all know, and this will be familiar to everyone in the room, but I think, as I say, it's useful to think about where we've been when we're thinking about where we might be going. So this, obviously, this wasn't the first case in Canada, the Carter case that dealt with medical assistance in dying. That first case was the Rodriguez case, which was not successful years before. But in Carter and Canada, we see the Supreme Court being asked again to determine whether the criminal code provisions which prohibited medical assistance in dying, whether they violated two provisions of the Charter, Section 7 and Section 15. So because I'm going to be talking a little bit about the Charter and how it applies in a couple of different cases this morning, I thought I'd just give a little primer. And again, a lot of this will be familiar to all of you, but I just want to make sure that we're all on the same page. So in Canada, all of our federal and provincial laws must comply with the Charter, and it's Canadian courts who are charged with deciding whether a law or an action by government complies with the Charter. And so to the extent that the law fails to do that, the courts have a range of remedies available to it, including declaring that a particular law is invalid. And so in terms of the way in which the Charter works, the Charter protects a number of rights, but those protections are not unlimited. We have a section in the Charter, Section 1, often referred to as the saving provision, and it allows the state to deprive individuals of rights as long as there are, here comes the legal language, reasonable limits prescribed by law and can be demonstrably justified in a free and democratic society. And there's a very formal analysis that happens at that Section 1 stage that I'm not going to spend much time detailing today, but suffice it to say it really involves balancing individuals' rights with broader societal interests. There's a balancing that happens there. And so as a result, when courts are engaging in this Charter analysis, it's really a two-step analysis. Has the right been infringed? And then might it be justified? Might that infringement be justified? Okay. So in the Carter case, as I've mentioned, the two provisions of the Charter were Section 7 and Section 15. And the litigants, there were three litigants in this case. Gloria Taylor, who suffered from ALS. Kay Carter's family. Kay had suffered from spinal stenosis, and the trial court had found that she had extremely limited mobility and suffered from chronic pain. And there was also a third party involved, the BCCLA, the British Columbia Civil Liberties Association, who is still involved in some of the litigation that's coming up currently. And sometimes the court allows an organization like the BCCLA to act as an applicant in a particular legal case. in order to represent the broader public interest, to provide a perspective that's a bit broader than the 2 or 3 individual applicant cases that are before the court. And we're seeing this again in the litigation that's coming up. So as we know, the criminal code provisions that were challenged were sections 241B and 14, which together meant that physician-assisted dying in Canada was illegal. The applicants had argued that the prohibition violated their Section 7 rights. And Section 7 protects the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice. The court found that there was a violation of Section 7, and in fact found a violation of all 3 of these aspects. With respect to life, the court found that the prohibition deprived some individuals of life, as it had the effect of forcing some individuals to take their own lives prematurely. Okay? Individuals might do that out of fear that they would be incapable of ending their lives when they reached the point that their suffering had become intolerable. The court also found that the criminal code provisions engaged both the rights to liberty and security of an individual suffering from a grievous and irremediable condition. The right to liberty was infringed because individuals weren't able to exercise decision-making with respect to their own bodily integrity and medical care. And the right to security was infringed because individuals were left to endure intolerable suffering as a result of being unable to access physician-assisted dying. The second step under Section 7 is about whether or not this infringement is in accordance with the principles of fundamental justice. And again, this is quite a legalistic analysis. A principle of fundamental justice is essentially a principle that's considered to be fundamental to the justice system. And the one that's often invoked in healthcare cases is whether or not the prohibition is overbroad. Is it overreaching? Okay, does it go too far by denying the rights of some individuals in a way that's not related to the objective of the law? And the court in this case concluded that this prohibition was overbroad, okay, that it violated the principles of fundamental justice. The court found that the objective of the criminal code provisions was to protect vulnerable persons from being induced to commit suicide at a time of weakness, but the court concluded that that complete prohibition caught too many people. Okay? It applied to people who were not vulnerable and who might wish to access physician-assisted dying, and the court found that, in fact, Ms. Taylor was one of those people. Okay? So having found an infringement of Section 1, the court moves on to the second step under Section 1 of the Charter. And it's at this point that the government has the opportunity to demonstrate that the provision can be saved on the basis that it's justified under Section 1. And so as I've mentioned, this analysis has a number of steps, and I'm not going to review each of them today. Suffice it to say that the court concluded that the total prohibition was not proportionate to the objective of protecting the vulnerable. And the court looked at a range of evidence on this. It relied on evidence related to assisted dying regimes in other jurisdictions. And the court found that there was evidence that a permissive regime was capable of protecting vulnerable persons, and that vulnerability could be assessed on an individual basis. And that's why we see some of the safeguards that we do in the legislation. Okay. So the court declared these sections to be invalid for a particular group of individuals. Okay. They found that these provisions were of no force and effect to the extent that they prohibit physician-assisted death for a competent adult who clearly consents to the termination of life and has a grievous and irremediable condition, which includes an illness, disease, or disability, that causes enduring suffering that is intolerable to the individual in the circumstances of her condition. The court expressly declined to make any findings about patient populations that were not before it. So, for example, the case of mature minors, those facts were not before the court, and the court decided that it would not pronounce on those particular situations. So it came out quite clearly to say that the scope of this decision is intended to respond to the factual circumstances of this case. The court in Carter also noted that there was a number of concerns raised by the interveners about a physician's freedom of conscience and religion, and the extent to which that impacted their constitutional analysis. The court made some important comments. It stated that nothing in the declaration of invalidity that they were proposing would compel a physician to provide assistance in dying, that the declaration was really limited to declaring those criminal code provisions to be invalid. And the court highlighted that the charter rights of patients and physicians would need to be reconciled when thinking about physician-assisted dying. The court was clear to say that that task, the task of balancing the rights of patients and physicians, fell to the regulatory colleges, CPSO, the other colleges, to Parliament, and to the provincial legislatures. Okay. So there was a suspension of declaration of invalidity for a year that was extended slightly because of the change in government. And following, during this period, we see Bill C-14 being drafted and becoming law. Now, I know that all of you are very familiar with this legislation and the requirements of it. Really, it's got two broad features. First, it sets out the eligibility requirements, the eligibility criteria around accessing MAID, and then it also sets up several safeguards. And so we know in terms of eligibility that it is only those people who are eligible for health services funded by a government a government in Canada, that people must be at least 18 years of age, and that an individual have a grievous and irremediable condition. I'm going to be talking more about that criteria in a few minutes, that there's a voluntary request, and that informed consent is provided. And the legislation, as I mentioned, sets up several safeguards. The request has to be made in writing. There needs to be 2 independent witnesses, informed that a request can be withdrawn at any time, et cetera, et cetera. I won't spend too much time getting into the nitty-gritties just yet of Bill C-14. Parliament recognized that there were some things that would need to be addressed after the law came into effect that couldn't happen in June of 2016. And so the law refers to some future actions. First and foremost, that there would be regulations made regarding the provision and collection of information that would be put into effect by Health Canada for the purposes of monitoring MAID. And we're going to see that those, Health Canada has been working hard on those regulations, and they will come into effect quite soon. The legislation provides for a review after 5 years, so there will be a parliamentary review in 2021 about this legislation. And there was also a requirement that there be independent reviews undertaken of 3 particular categories of individuals who might possibly become eligible for MAID. Those would be mature minors, individuals who were requesting MAID where the sole underlying medical condition was mental illness, and whether or not a MAID could be requested by advance request. Okay. And so we've seen this task has been, the Canadian Council of Academies has been charged with undertaking those reviews, and they've been working on those. I expect that we'll see some reports out of the CCA relatively shortly. Okay, so before I talk more about grievous and irremediable condition and what that means and how the courts have interpreted that criteria, I want to spend a few minutes talking about conscientious objection. So the federal legislation is silent, relatively silent, on conscientious objection. It states in the preamble that nothing in this act affects the rights to freedom of religion or conscience. And so the approach to addressing healthcare practitioners' conscientious objection to MAID has really been dealt with by the provinces. In Ontario, the CPSO has set some guidance around conscientious objection in its human rights policy. And it also has set out an effective referral policy, or an effective referral requirement in its MAID policy. And that policy requires that physicians who are unwilling to provide certain elements of care for reasons of either conscience or religion provide an effective referral to another healthcare provider. And the policy defines what that effective referral requires. It means that the referral has to be made in good faith. It has to be made to a non-objecting, available, and accessible physician or other healthcare professional or agency. And it must be made in a timely manner to allow patients to access the care. The CPSO has published a fact sheet that has listed different ways in which physicians can comply with the policy's requirements, so some useful guidance to members. And so, for example, this effective referral policy means that physicians who are practicing in hospital, for example, could include an identification of a point person within the institution or practice group who would facilitate referrals or provide the health care to the patient. Or it might include accessing a triage system for matching patients directly with non-objecting physicians in the institution or practice group. The fact sheet also indicates that physicians could connect patients with an agency charged with facilitating referrals for the healthcare service. So the court, for example, in the case that I'm going to be discussing in a couple of minutes, refers to the Care Coordination Service in Ontario as one such agency, although we're still in the early days of that Care Coordination Service. So this effective referral policy, which, as I've mentioned, is found in two CPSO policies, has been the subject of a constitutional challenge in Ontario. The Christian Medical and Dental Society of Canada, the Canadian Federation of Catholic Physician Societies, Canadian Physicians for Life, and a number of individual litigants have argued that these effective referral requirements in these two policies violate the Charter, violate Section 2A and Section 15 of the Charter. Section 2A protects the right to freedom of religion and conscience, and Section 15 protects the right to equality. The applicants in this case argue that these provisions, that the effective referral policy violated their freedom of religion and conscience because by effectively referring, this essentially constituted complicity in the provision of certain elements of care to which they object. And this case wasn't simply focused on MAID, also include concerns around care relating to abortion, contraception, and others. Okay. They also argued that the policies create a distinction, so they discriminate because they distinguish between physicians who are non-religious and do not object to the provision of medical services on religious or conscientious grounds, and on religious physicians, so that there's a distinction in the law that results in discrimination. So this case was heard in Ontario by our divisional court, and the court agreed that the policies violated the rights to freedom of religion and conscience, but did not agree with the arguments around discrimination. So found that there was a Section 2A violation. So once we've looked at the infringement, we move over to Section 1, is the infringement justified? The court in this case found that the violation of the infringement of the right to freedom of religion was justified in under Section 1, so use the saving provision. And the court really, it's quite a long analysis, but the court essentially concluded that the infringement was justified for a number of reasons. So first of all, the court, when they're thinking about whether or not a particular government policy or action is justified, will look at the objective of that policy. And here the court concluded that the objective of the effective referral policy was to ensure that patients had equitable access to health care. Okay. The court looked at the evidence that was provided and concluded that physicians play an essential gatekeeping role in Ontario, that gatekeeper function really means that patients need their family physicians to provide them with information and meaningful referral, because most citizens can't otherwise access the healthcare system. They can't enter this system, and so ensuring that there is consistent practice among physicians is critical. Okay. The court also engages in this balancing exercise and looked at some other alternatives to the effective referral policy. So it spent quite a bit of time looking at how other provinces and how other jurisdictions deal with balancing rights around conscientious objection with access to medical assistance in dying and other types of health care that might be the subject of a conscientious objection. And the court found that the route that the CPSO in this particular case had taken, that was an appropriate policy, that it sought to balance access for patients with the rights of physicians, and as a result that it falls within a range of reasonable alternatives for addressing physicians' conscientious and religious objections. And then finally, the court looks at balancing the effects of the policies, the beneficial effects on patients and the deleterious effects on physicians, and found that when engaging in this weighing, what the court concluded was that avoiding harms to patients really outweighed the deleterious effects on physicians who conscientiously object. The court identified a number of potential harms to patients because of either delayed access to the requested medical service, to the loss of eligibility for a service, to feelings of stigma or emotional distress, as compared to what it characterized as the various deleterious effects on the religious practice of physicians in their health and professional life. Now, my understanding is this case is being appealed, so this is not the final word on this in Ontario, but this is where we're at in terms of the CPSO's effective referral policy. Okay, so moving away from conscientious objection, I want to turn back to look at the statistics a little bit more carefully, and how the criminal code provisions, how the legislative framework is operating in Canada at the moment, and thinking about whether or not, I want to discuss a little bit about whether or not those eligibility criteria comply with the Charter and some of the litigation around that. So in terms of what's happened since the law came into force in June 2016, Health Canada has issued 3 interim reports on MAID in Canada, and these reports really provide some basic information on the number of MAID cases in Canada and the profile of those who are choosing MAID. So a couple of things to note about these statistics. There has been an upward trend. The number of MAID cases has been increasing gradually since it first became legal in 2016. Second thing to note is that Health Canada has reported in its third interim report, has reported that the number of deaths resulting from MAID accounts for roughly 1% of total deaths in Canada during that reporting period, and that's consistent with other countries where medical assistance in dying is legal. Okay, we see in those other countries the range is somewhere between 0.3% and 4% of total deaths are attributable to medical assistance in dying. And so focusing for a few minutes on the third reporting period, the data illustrates that medical assistance in dying, and this will come to no surprise to anyone in this room, that most common in patients who suffer from cancer-related diseases. Okay, we see that the majority of cases are in patients who suffer from cancer-related diseases, but we also see patients who are suffering from neurodegenerative diseases, circulatory, respiratory diseases, coronary artery disease, COPT, other diseases in those categories are also choosing MAID. The statistics also demonstrate that MAID is almost always administered by physicians rather than nurse practitioners. Okay. In terms of the location where MAID is occurring, generally this happens either in hospital. Patients are receiving MAID either in hospital or at home. Those are 80% of cases, so sort of 40% in hospital, 40% at home. There are some cases that are occurring in long-term care facilities, nursing homes and hospices, but as I say, really the bulk of these cases are either in hospital or at home. MAID is more common in urban centers rather than small centers, and we can think of a whole host of reasons why that's happening around access and other issues. In terms of gender, this is a fairly even split between men and women. 49% of patients were men, 51% women. The age ranges vary, but the average age is approximately 73 years. The statistics released by Health Canada also offer some information about requests for MAID. This is an area that Health Canada is very interested in and has been paying close attention to. And so you can see on, this is a select number of provinces, but it does give us some sense, it gives us sends a couple of important messages. The first is the most frequently cited reasons for why requests for MAID have been declined. So why a patient, why a physician, or a nurse practitioner, although it's largely physicians, would conclude that an individual was not eligible for MAID. The first is loss of competency. So the patient is not competent to consent. And the second is that the physician or nurse practitioner concludes that death is not reasonably foreseeable. Health Canada has also noted that there's a gap between the number of requests that are being reported and the number of cases where an individual dies prior to the completion of the assessment process. So there's we can look, for example, in the third period here, July 1st to December 31st, there was 1,066 requests for medical assistance in dying, but 149 cases where individuals had died prior to the completion of the assessment process. And again, there's, I'm sure, a whole host of reasons that the medical experts on this panel will likely be speaking about, but we are seeing this gap between requests and cases. Okay, so let's turn to the criteria of grievous and irremediable condition. So in the legislation, the law defines what constitutes a grievous and irremediable condition, and it sets out several criteria around around this definition, which has meant that lawyers and doctors have spent a good deal of time thinking about what these actually mean. So grievous and irremediable condition is defined by law as a serious and incurable illness, disease, or disability. The patient will be in an advanced state of irreversible decline in capability. That illness, disease, or disability, or the state of decline causes them enduring physical or psychological suffering that's intolerable to them and that cannot be relieved under conditions that they consider acceptable. And the natural death has become reasonably foreseeable, taking into account all of their medical circumstances without a prognosis necessarily having been made as to the specific length of time that they have remaining. And so I'd like to spend a few minutes talking about each of these requirements and how they've been interpreted. Yeah. So the first is reasonably foreseeable natural death. This is arguably the vaguest, thorniest, I'm not sure what the word is, but certainly been the subject of much discussion about what is a reasonably foreseeable natural death under the law. And there's been some, as I've said, there's been a case in Ontario around this criteria about what this means. There's different possible meanings associated with this requirement. So, for example, it could refer to the timing of death. So the probability when a person will die a natural death, sort of the when. Or it could refer to the cause of death, so that the patient would have to be diagnosed with a terminal illness, right? The person's been, has a certain physiological condition that's been diagnosed, which leads to the probability of how that person will die. So this is sort of known as the how approach. There's been some question about whether, when interpreting the reasonably foreseeable requirement, that both the when and the how have to be present. So the patient has to have, does the patient have to have both a diagnosis and does the time of death have to be within a certain period, or can these criteria be standalone? And it appears from the Ontario case that I'm about to discuss that these can be individual considerations, so that the when of the death or the timing could be a sufficient basis upon concluding that the natural death is reasonably foreseeable, but that's not necessary, or that the cause or the how of death is sufficient for concluding that natural death is reasonably foreseeable, but again, not determinative. And so we see in the AB case that the court is asked to address this very question. So this is a lower court decision. It's not binding, but it gives us some important insights about this statutory criteria. So essentially what happened in this case is there were two physicians that concluded that a patient who is known as AB, that she met the criteria under the criminal code, that she met the grievous and irremediable condition criteria for a medical assisted death, and one of them was willing to provide her with the assistance. However, a predecessor physician expressed the view that he did not agree that AB met the criteria of the criminal code. He felt that AB's natural death was not reasonably foreseeable, and as a result of that opinion, there was no physician who was willing to provide AB with medical assistance in dying. The physician who had been prepared to provide the assistance was still of the view that she was qualified, but he declined to provide the assistance because he was afraid of being charged with murder. He was worried that he'd be charged under the criminal code. And so even though she qualified, there was no physician who was prepared to assist her. So AB went to court seeking a declaration from the court that if a physician provided her with medical assistance in dying, that they would be protected from criminal charges. Okay? This is not the typical way in which a case gets to court. Okay? And I'd say a good half of the decision is spent figuring out what the court can do in terms of providing a remedy to this patient. The court was not, perhaps not surprisingly, the court was not willing to issue the kind of declaration that AB wanted that would mean that the physician was essentially immune from prosecution. Instead, what the court said it would do is it would issue a declaration indicating whether or not a patient who is in AB's circumstances would fit the statutory definition of reasonably foreseeable natural death. Okay? So, who is AB? AB was an almost 80-year-old woman. She had an advanced and incurable disease that she had suffered from for about 25 years. Okay? She suffered from osteoarthritis. And the court found that she was suffering from uninterrupted, incredibly excruciating pain. She'd been diagnosed with osteoarthritis in 1982 when she was in her 40s. And at that time, she was working full-time to support her family. Despite the fact that she was in significant pain, she continued to work until she was in her mid-50s, at which point she decided to retire. She couldn't work anymore because the pain was overwhelming. After she retired, she moved to live with a family member, and her condition continued to deteriorate. She had multiple operations, knee replacements, hip replacements, metal rod implants in her legs and in her back. The pain could not be managed, and the surgeries were not helpful. She lived with her family until she was in her early 70s, and at that point it became clear that they couldn't take care of her any longer, and so she moved into a nursing home. She needed full-time care. At the nursing home, her condition continued to deteriorate, and by 2015, her pain became unbearable to her, and she started to think about medical assistance in dying. She had had a number of conversations with her rheumatologist about the pain. The rheumatologist suggested more operations, but the patient refused further surgeries. She felt that the previous surgeries had not helped her pain. In fact, they had exacerbated it. And so her rheumatologist prescribed increased medication, fentanyl, morphine, prednisone. But again, the pain was not controlled. So by early 2016, her pain had become so intense that she was unable to sit in the dining room at the nursing home. She was crying in pain, and she was worried about making the other residents uncomfortable, so she decided that she wouldn't leave her room. She would stay in her room most of the time. Okay? So in terms of this condition, her medical condition is not imminently terminal, right? She's immobile due to constant arthritic pain, and the court found that that pain was intense. Despite every effort of her physicians to manage the pain, she was experiencing significant pain that was not being managed by medication. She felt that there was no further treatment options, and that she really had no future other than to live in pain until she was allowed to access MAID. And so the court here had to interpret the when and the how with respect to the reasonably foreseeable natural death. The court in this case concluded that the when interpretation, so the determination of time, is not determinative. And so I've put some of the court's language up here on the slide. The court concluded that that natural death need not be imminent. What is a reasonably foreseeable death is a person-specific medical question to be made without necessarily making, but not necessarily precluding, a prognosis of the remaining lifespan. And the court goes on to say that in formulating an opinion, the physician need not opine about the specific length of time that the person requesting medical assistance in dying has remaining in his or her lifetime. The court also concluded that when considering the reasonably foreseeable natural death criteria, that the patient need not have a terminal disease or condition. So this is the sort of the how interpretation, the how approach. He concluded that the language reveals that the natural death need not be connected to a particular terminal disease or condition, rather is connected to all of a particular person's medical circumstances. The language does not require that people be dying from a terminal illness, disease, or disability. And so in this case, the court concluded that AB met the statutory criteria, that she was eligible for MAID. We also have some sense of what the reasonably foreseeable natural death criteria is from the Attorney General of Canada, which is quite helpful in some ongoing litigation that I'll talk about in more detail in a couple of minutes. And this, the interpretation here is from the Attorney General's Statement of Defense in the Lamb case. And in particular, the Attorney General spent some time in their written arguments explaining what is meant, what their interpretation of a reasonably foreseeable natural death is. The Attorney General notes in their factum that eligibility is not limited to those who are dying from a fatal or a terminal disease. And the Attorney General explains that to become reasonably foreseeable, a natural death must be reasonably anticipated to occur by one of a range of predictable ways, so not a terminal illness, but a predictable way, and within a period of time that is not too remote. So it doesn't specify a particular time period, but talks about remoteness, okay? So we have some indication, as I say, from the Attorney General about the why and the how, but of course this is undoubtedly going to be the subject of further litigation. So the second requirement is around serious and incurable condition. And there's some question about whether incurable means incurable by any means, or does it mean incurable by any means acceptable to the patient. So under that latter interpretation, that means that it's only, the only possible chance of a cure comes from an available treatment that is unacceptable to the patient. That would be deemed incurable. And it's this latter interpretation that really appears to be consistent with the law for a couple of reasons. First of all, that interpretation is consistent with how we approach patient autonomy and the need for consent to a medical treatment. Any other interpretation would effectively be requiring patients to undertake treatments that they wouldn't otherwise consent for in order to be eligible for MAID. And it's also consistent with some statements that the Minister of Health and Senior Counsel for the Department of Justice have made in the context of the Senate committee hearings around the passing of this legislation. When they appeared before the committee, they both stated that incurable should be interpreted as including the limitation sort of by any means acceptable to the patient. So more straightforward, arguably, than reasonably foreseeable death. In terms of intolerable suffering, it seems in terms of an interpretation of intolerable, there's been some question about whether this means literally impossible to bear, or whether it is the question about suffering being intolerable is somewhere on a spectrum whereby it's towards the end of the spectrum, towards one end of the extreme, and that is likely the most reasonable interpretation, especially given that there's a 10-day wait period between the signed request and the confirmation and receiving of MAID. And then in terms of irreversible decline in capability, again, there are a few issues regarding this requirement. Does capability include both physical and psychological capability? Again, it's reasonable to interpret this as including both. The legislature could have narrowed the language in the statute, and they chose not to. Another issue that arises is whether the decline in capability can have stabilized or whether it must be continuing. Given the statutory language, it appears that a decline in capability that has stabilized is sufficient, okay? And this is really an objective assessment by a clinician as opposed to a subjective assessment by the patient. So those are the four criteria. As I mentioned at the beginning of, or earlier in the talk, there is some question about whether there will be an expansion of the eligibility criteria. And so there is an independent review that's ongoing by the Council of Canadian Academies around psychiatric illness, advanced directives, and mature minors. The Canadian Council of Academies has struck 3 separate committees to consider these, and their work is well underway. I'm not going to spend much time at all today speaking about this, but I just did want to highlight one potential case, and this is an area where we might have some, where we might see some litigation, is around advanced directives. And so some of you may have seen this story on the CBC last week, the Nova Scotia woman who is opting for MAID at a point earlier than she would like. So Audrey Parker, she's a Nova Scotia woman, and she is saying that she is going to end her life earlier than she would like because she's worried that doctors will deny her the procedure if she loses her mental capacity to consent before that point in time arises. So Ms. Parker has stage 4 brain cancer that has spread through her bones and to her brain. She's receiving palliative care, but she's acutely concerned about losing cognitive capacity because of these metastases to her brain. And so she has taken this rather drastic step of opting for MAID at a time earlier than she would otherwise choose. This case raises lots of really important questions, including the frequency in which patients find themselves in these situations. Jim Cowan, who is the director of Dying with Dignity, says that this is not an isolated case, that this occurs with some frequency, and that this is an area where the government really needs to take some action. So as I mentioned, the question about advanced directives is one of the areas where there's an independent review going on. And so as a result of those independent reviews, we may very well see some legislative reform by Parliament. But in the meantime, we also have some litigation ongoing. I'm just going to mention one of these cases, the Lamb case, which some of you may be familiar with. So this is Julia Lamb. She is challenging the current legal framework, arguing that it's not constitutional. And she's doing that with the assistance of the BCCLA. So the BCCLA is once again involved in the litigation around access to MAID. Ms. Lamb is arguing that these sections, the current framework, infringes her right to life, liberty, and security of the person. She suffers from spinal muscular atrophy, which is a hereditary disease that causes weakness and wasting of the voluntary muscles. And so her argument is that the requirements around a condition being incurable and the requirements around reasonably foreseeable natural death violate her Section 7 rights, okay? She argues, in addition, that those sections, the limitation, the limited access to MAID, also results in discrimination because the effect of the legal definition is that they provide certain categories, or they prevent certain categories of people from being able to access MAID. So especially younger people, okay, when we think about that remoteness criteria. In addition, people who are suffering from material physical disabilities would be a category of people who would be prohibited from accessing MAID. So the federal government, as I mentioned, they are defending the provisions as constitutional, and we'll wait to see how this case is dealt with, but the BCCLA's and Ms. Lamb's, one of their primary arguments is that the criteria that's in the criminal code is not as broad as what the Supreme Court foresaw in the Carter case, that it's not consistent with the Supreme Court's decision in Carter. So the last slide I'd just like to, or the last point I'd just like to mention is around information disclosure. So this is the regulations that are coming into force. Health Canada has been working on these regulations around the reporting requirements. Health Canada and the federal government have taken the position that information disclosure is really critical when we're thinking about MAID for a number of reasons, not least of which is ensuring that there's transparency in the system, the need to foster public trust in the application of the law. And so the hope is that having robust data on MAID will inform ongoing discussions about MAID in Canada, that this data will be available to researchers to conduct independent research. And so the reporting frameworks have been recently released by Health Canada. The way that this is going to work is through a portal, what's known as the Canadian MAID Data Collection Portal. And the reporting obligations are going to fall, not surprisingly, on physicians and nurse practitioners. They apply to written requests for MAID. For pharmacists, pharmacists will also be required to report where they've dispensed a substance in connection with the provision of MAID. And so in terms of this written request, what might this look like? When will these reporting requirements will be triggered? The information that Health Canada is providing is that if there is a request it needs to be in writing, but it doesn't need to be formal. It could be by email or by text, but it needs to be more than an inquiry or a request for information about MAID, that will trigger the reporting requirements on the physician or the nurse practitioner. My understanding is that the various regulatory colleges will be providing guidance to their members on how to meet these reporting requirements. And so I'm sure there will be more to come in terms of the details around that. But there is some information that's now posted on the Health Canada webpage if you're interested in taking a closer look at it, about the timelines and the circumstances under which the reporting requirements will be triggered. So that is the legal view. I'm going to stop there. I've been talking for a long time. And open it up to discussion and questions. Thank you.
Okay, so once again, if you could come to the mics for questions. And give it a few seconds, because I think the boys at the back have to switch it over, we've noticed. And I believe we have about half an hour for questions, is that correct? Okay. So the mic's all yours. Or if you make a move, it may just be for coffee. Did either of the panelists, I know Marjorie's been rapidly writing some notes down there. Go ahead. Saved.
I'm always up here. We're talking mainly right now about patients requesting MAID. I'm wondering if someone would comment on the London gentleman who's in hospital now, who is trying to get self-care or organize his healthcare at home, and was approached by hospital administration to say, why don't you consider MAID?
Yeah, have you heard this case? Yeah, have you heard of this?
You can start and then I'll
Okay, I was going to say, yeah. So this is just to give a bit of background, and then I'll turn it over because I've really been talking for too long. So this is the case of Mr. Foley, who is essentially, as Judith says, has put in a request for additional healthcare services to assist him in terms of moving him home. And the response was, well, we can provide you with MAID services, but your request for these additional services sort of falls outside the scope. I think that raises some really important questions that the legislation doesn't adequately address, and that makes legal scholars and courts quite uncomfortable. So when we think about accessing care, the courts have been very clear that there is no Section 7 right to health care. And I think this case puts into stark relief the sort of restrictions or the place where law really ends. And we need the healthcare system to step in and be making some important decisions about prioritizing palliative care and MAID, and where some of the funding is going to happen. Courts have traditionally been quite uncomfortable with navigating those resource allocation questions, but I certainly think that this is it's a very troubling case.
I have a young man in my practice who has a progressive autosomal dominant degenerative muscle disease, and he probably is going to die in his 30s, but he's about 19 or 20 right now. And he had some mental health issues, and my locum referred him on to our local mental health unit, and the social worker provided him with information on MAID. So he came into my office and he was quite tearful, and he said he thought this is something he should do because he'd never really reflected on the huge burden he was in his family until he talked to the social worker. And I know his family truly love him, and I know his sister really supports him, and she's his care aide. And so we had a long talk, and I sort of tried to talk to him about how valuable he was. Even though he is a disabled person, he is very valuable in light of many people. So that's one comment, then that really made me truly worried. And I know, in all honesty, when the College of British Columbia set up the MAID guidelines, they thought about all this stuff. They truly tried to write in protection of people. What I observed in our community is that it's almost like MAID became another subspeciality, and people were galloping towards becoming qualified and super enthusiastic. And I was kind of perturbed, because I'm very happy to talk to my patients about it, and I would never actually perform the act, but I would be willing to be there with them at the end. But I've never been asked to be. I've never been asked for any medical records on my patients who've accessed information of MAID, and the two who have tried to complete MAID and the one who did. I was never invited to be part of that, and I received a text to say your patient is destined for MAID on the 11th of March. I'm sorry, you're on holiday. You know, it was like, so I think the sober second thought for me is I appreciate the need people feel to access these services. I have compassion for suffering, but I'm truly troubled of how we ethically defend the vulnerable. And I'm truly troubled how we ethically defend the rights of physicians not to do something they don't want to do. If I loaded a gun and handed it to you, Rachel, and you were going to shoot somebody, does that not make me complicit? I think under the law that makes me complicit. So if the poor pharmacist has to load the syringes and he doesn't want to, doesn't that make him or her complicit? And that's what they're arguing, and yet our colleges are saying, well, you probably need to do that. In Ontario, they haven't done that in BC. In fact, in BC, it moves so rapidly to be an easy access thing other than remote rural communities, that there's a website, there's a hot number. I don't even know what's happening. Like, basically the patient can phone this number, it's all in action, and suddenly it's a go. So we can't access long-term care beds, and we have trouble accessing all our palliative care services, but these services were rolled out in 6 months. And really very slickly, and have all the provisions and supports in there. even things like, we even worked out logistics about how do we fly a plane up to rural communities with a lockbox that has all the medications in it needed and a backup lockbox in case the first set fail. So they thought all these things through, but we're not doing that supportive thing. And I think when we think about our elderly, we all will become old if we live long enough and don't get hit by a bus. We'll all become less capable. We'll all become less firm. We'll all need some support. And my fear is that if society cannot walk with oldness and suffering and infirmity and see it with compassion and see it as normal, do then the people who are old within a decade or so start to feel like it is their duty to shuffle off the mortal coil and not inconvenience the rest of us? So I'm kind of in a very broad mind about it, but I have some serious concerns about how fast we're moving towards this being a solution for infirmity. I didn't say that out loud, but I kind of said that.
I think in a way, actually, that Marjorie's already answered my question. I'm not in BC, I'm in Ontario. But I was wondering about a way of, in essence, satisfying both sides, people who want to access MAID and don't have a particularly supportive physician who perhaps is a conscientious objector, and at the same time the physician conscientiously objecting to the procedure and not wanting to be complicit, being the setting up of some kind of centralized patient self-referral system.
And that exists in BC.
And so that exists in BC. I didn't know that.
Well, the other thing
exists in Ireland as well.
In
yeah.
Ireland? Oh.
The other thing the College of Physicians and Surgeons in BC did, and this was in a case of a physician who would not prescribe contraception and was brought to the college as a complaint. And we had that physician post on their wall. For my own personal reasons, I do not prescribe contraception. Here's the name of a physician who's very willing to see any of my patients who request a consultation for contraception. And please, you know, blah, 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 what all the rest of it. And that satisfied the college's wishes that the patient had access to care, but it had to be posted in every exam room. So there are ways around allowing access to information and care, because I don't personally feel I have the right to imprint my belief system on anyone. So I think patients have a right to access to information, and BC kind of solved that. If you can get on the internet anywhere, you can get all this information immediately.
At the same time, you comment that you are never asked for medical records, you're never invited to be involved in these discussions. How then are we to do our due diligence when making an assessment for eligibility of MAID without the input of
I'd refer that to my legal colleague, but I think the intent of the court is that you would ask the primary caregiver for information, because part of the BC intent in they stipulated you may not unreasonably hold records or referral. So meaning that if somebody asks me for information, I need to give it to them. But nobody ever asked me. So I was quite amazed, because I knew these patients for 30 years, so I was kind of stunned that nobody thought my input was useful.
Is there a requirement to have medical records to prove that someone has a particular condition? No.
But there was a case where a gentleman accessed MAID, and I think it was actually in the States, and he had arrived, and he initially was from Taiwan, and he came and he had pancreatic CA, and he accessed MAID, and he completed it. And when they finally did get the records, he never had pancreatic CA. It was actually a suicide. So I think the records are essential. In our community, because IHA is so confidential, almost anyone with a medical degree or a pharmacy degree in the hospital can access your records. So I'm assuming they read my patients' records through IHA.
Thank you very much.
I'm hoping.
I have had 2 patients request referrals. Our center, the physicians and the palliative care docs have decided that's not a service that they're going to provide. And both of the patients had metastatic cancer. The man was not as close to the end of his life as the woman. Both of them, one was, the lady was metastatic breast cancer who had seen multiple family members die of cancer, and was determined this wasn't going to be her death, that slow decline. And the gentleman had metastatic colorectal cancer, and he was single, and he didn't want to be a burden to his family. And I was a bit shocked by his request, and I just sat down and spent some time talking to both of them and talking to them about palliative care services and what was available in the community, and would they allow me to make a referral to our palliative care doctors, and then they could reassess the situation. And for the gentleman, that was all he needed. He got the services. He wasn't a burden to his family, and he died in hospice. And the woman actually, although initially reluctant to receive palliative care, did allow them to come and see her in the community, and died with palliative care services. And I just wonder if there's statistics being kept on how many patients proceed to MAID not ever having been seen or assessed by a palliative care physician, how many people request the referral but don't ever go further than that, and whether the Palliative Care Physician Association has I assume you have a statement as policy, a standing on the matter, because to me, I would think, it's reassuring to see it's only 1%, that the number is pretty low. It gets a lot of attention, but it's not, not 99% of our patients are pursuing that. But I really do think we pay for $10,000 a month drugs, but we won't provide $10,000 for palliative care and a life care. It just blows the mind. Like, right now, those drugs that we've been hearing about all weekend could cost $100,000, but it wouldn't cost $100,000 for a patient to have good end-of-life care, I wouldn't think. Maybe, Andrew, you could yeah, so why are we not providing that care to our patients? Like, why is end-of-life care so poorly valued, lowly valued, that we don't put money there?
You raise an excellent point, Mary. It's been said before that we come from a society that really fears death and really doesn't want to go there, and that doesn't become part of our common conversation. That may have something to do with it. I will state or answer an earlier question of yours that the Canadian Society of Palliative Care Physicians did actually come up with a position paper on medical assistance in dying, and that was actually done after they took a survey of the membership to see where the membership stood in terms of either being prepared to participate in medical assistance in dying. What they found out was actually 8% of them, I think it was 8% of the membership, were prepared to provide that procedure for their patients. So, the society actually represents a composite of individuals with differing beliefs. I've been down this road with a patient, and actually I'll step back before I go into that. I began to hear twitterings from the long-term care physicians in Sudbury that they were going to simply refer their patients to palliative care for this procedure. And medical assistance in dying is really the complete antithesis of what palliative care is all about. And that was really in some of the position papers that the Canadian Society of Palliative Care Physicians published. It's really about, palliative care is about adding life to your weeks, not taking weeks from your life. I had a very interesting experience that went over many months with a patient and family. There's a fellow who presented with leg weakness and essentially became lower limb paraparesis on the basis of a spinal lymphoma. And he was in hospital for probably about 3 months, receiving chemotherapy, rehabbing, etc. And it was through the time when the Supreme Court was making their musings about the legislation. he was discharged. Unfortunately, about 6 or 7 months later, ended up in hospital again with leg weakness just before Christmas, and he'd clearly relapsed. Over Christmas, he made a request to one of the covering physicians that he was interested in MAID. And when I came back in January, I had this request. And it put me in an awkward position because I really, as an individual, I have some strong feelings about MAID. Yet I also, as a physician, am very principled in the notion that about patient autonomy and patient choice. And how could I travel this road now presented, or this path presented to me? It came down to me, or for me, deciding that really, when you look at medical assisted dying, you can break it down into two pieces. There's a process and there's a procedure. I think as most practitioners can manage the process where we actually engage in these conversations with patients and explore the request. That's something that we do in other areas of medicine or different topics, and we're actually very good at it. The procedure, that's a different issue, and that, anyway, providing that dichotomy may help some of you. So the other thing that was at play in this fellow was that he was starting to pick off cranial nerves and was having intense facial pain from his disease, leptomeningeal disease. So there was a certain element of time here, and Health Sciences North did not have a process in place. So we scrambled. We actually shortened that 10-day waiting period, and he had the procedure done on a weekend. Upon reflection, I think, and it came out talking to his wife later, that he'd been having these thoughts actually during when the Carter case was before the Supreme Court. And he thought that at any point, if he'd relapsed, this was what he was going to proceed with, and the family sort of were quite supportive in that. So the other lesson for me in this is that I think we need to consider engaging patients in this discussion upstream. Now, it's not a question of trying to solicit their support for the procedure. I think it could be done in a very gentle way where, for instance, you may have heard about this process. Is this something that you may want to discuss with me in the future? It's really not you're not leading them in any direction with a question in that way, but anyway, just a thought.
I had one other question that came to me after Andrew said something, but I was wondering, Vanessa, in any jurisdictions, does the power of attorney have any?
No.
Okay.
No. The law is very clear that it is first-person consent at both stages. So when you make the request and right before the patient receives MAID.
In answer to your question too about research, I think there was a paper not long published from BC looking at over 1 year, 250 cases with a group of physicians requesting MAID. 112 fulfilled that wish and 35 weren't eligible. And what they found was a lot of people just want to know if it's a possibility. And once they know it's a possibility, some of their anxiety about internal suffering goes away. Also, the patients who were enrolled in palliative care had less fears about autonomy in care if they were already in palliative care. So being in palliative care did skew what their feelings about where they were accessing it. So for those patients, it was if symptoms could not be controlled was their main reason.
I'd like to thank Andrew for his comments because I think they're gently and artfully stated. I'm a Northeast BC rural physician and a provider assessor, and I have come to that arena on the background of 40 years of provision in the early pregnancy option service, and I find it somewhat historic where we are today with this dilemma. It has lots of similarities to where we were 40 years ago with another service that is now accessed by many women. One of my sons got married here just recently to by a non-pastoral pastor, as he termed himself, and one of the other physicians at the party got into discussion about medical assistance in dying, and in the end, his comment was that we sometimes, in the church, we get tied up with doctrine and we don't hear stories. And so I'm also a CAMAP member and a medical lead for Northern Health for this service. I think it's very much about patient autonomy. What really impresses me is that there's only a small percentage of people that really want this autonomy, and those that do have felt strongly over a long period of time. It's not a reactionary thing at the end. It's been discussed by family. They've tried to often discuss it with their physicians, and it's not been heard, so we get tension near the end at the end of the trajectory where death is imminent or loss of capacity with the narcotics that and sedation that is necessary to control terminal symptomatology, compromise abilities, and we have to waive the 10-day free period. The majority of people that I've provided for have been provided in their home. I think they've all had an awareness of palliative care options. I think it's very interesting that in the countries, Belgium and Holland, that are 2 decades ahead of us, that it's never been more than 4%. When we had the first CMA sponsored meetings around this from the Physician Initiative, the Dutch presenter was, it's the patient, it's not nearly as patient-centered there. They have to accept almost all palliative care measures before they're granted permission, and once assessed and given approval, if they don't access the service within 3 weeks, it's withdrawn. And I thought, I was sitting there thinking, God, Canada did it right. It made it very patient-centered. And then he revealed the true statistics, and he talked about the 200 people in the last year that had accessed MAID and been provided in Holland that had early dementia. So yes, in the patient's eyes, they may have had a grievous and irremediable condition. Their loss of capacity and functionality was minimalistic, and death was a decade from the foreseeable future. So I thought, I spoke up. How can you, on one hand, have such a paternalistic system, and yet you're stepping into the void here, and you're giving us a bad time about how we've done it? I think from the CAMAP organization and at the health authority level, we're not worried about compromising vulnerable people. We're actually concerned that the vulnerable, the street people, the First Nations people, they actually don't have access. One of my jobs as medical lead is to try and sort out how are we going to respond to the first request that will come from a reserve nation, given the complications of that society. As a provider, what impresses me most is that the majority of people value life in whatever form they endure it right to the bitter end. They're never going to be interested in MAID. It's only going to be a small percentage of people, but for them, it's huge. And the other comment I'd make is that most of these people that I've been providing for are surviving spouses, and the journey of the death of the the spouse and that burden that they see, that one of the existential motivations is most definitely that they're trying to protect family from another journey like that. The other sort of comment I made is that I had a minor understanding of what existential pain is until I entered this arena. Existential pain is a massive thing for some people.
So I think we have by my watch 4 minutes until the next presentation. So if we could keep our comments or questions as if they can possibly be quick, but as quick as we can.
I think, Andrew, when you brought up the process issue, it's pulled together a lot of things that we've talked about this weekend. We talked about advanced directives, and I think I'm realizing here that there's a lack of communication, perhaps that we need to start earlier talking to patients about palliative care so that they know what is available to them, and that this is the standard of care before we start adding MAID into the discussion. So we need to go once. We're not necessarily doing it the right steps right now.
So a quick comment from the psychology aspects of it is physicians are afraid of failure. And once we no longer have treatments to offer, we often retreat in our hearts whether or not we tell the patient that. We become less visibly available to them. And I think what we need to learn is the courage to pony up and say, what are you afraid of and how can I help you? And the courage to walk that journey to the end, even if there's not a single pill we can give them, that we stay with them. And I think that time pressures in current practice make that difficult for us, and the number of different caregivers floating in and out of our patient. But that is the role of the physician, and that does bring comfort, and it is actually a treatment. It's not palliative, it's not a placebo, it's a treatment.
And I know I'm just the moderator, but I do have a comment. What's new? I would highly recommend, based on that alone, that everybody have a look at the Serious Illness Conversation Guide. It is a guide that is a way to have conversations that's been vetted. That's for every clinician to be able to sit and ask about fears, worries, concerns, things that have commonly been left to palliative care, but that we all can and should have some proficiencies in. Again, so we have got 1 minute, and Mary's going to shoot me if I take into her time. So quick.
Mine's quick.
Perfect.
Mine's controversial, though. So it's really a question for Vanessa, for the future, really. So I very much would like to have in my living will something to do with end-stage Alzheimer's or dementia. I would very much like to be able to undergo a process or have the option of MAID type of thing if I was in that condition. And I think the competency issue is really stopping families and people from what they would want their wishes to be in that situation, which I think is a huge area of something that should be explored in end-stage Alzheimer's and dementia. So I wondered what you thought maybe the future will predict, because even on patients who lose competency while they're waiting for a process of discussion or decision, that to me seems inappropriate. If they are able to make a competent decision at the time and put that into their will and have family with support, I think it's wrong for somebody else to make that decision that I may have to live 10 more years with end-stage Alzheimer's, not appreciating or enjoying the quality of life that I'm providing for me or for my family.
I think that's a great question. I know we're just about out of time, so I will just say briefly, and maybe we can talk once the panel wraps up, but I think it'll be very interesting to see what the CCA report around advanced directives says about this issue, around, you know, how can we promote patient autonomy in this with respect to MAID when thinking about advanced directives, and what are some of the vulnerabilities that we need to protect against. So for example, if there's going to be a legislative regime that's going to allow this, you know, will the safeguards be different? And what might those safeguards be to address some of the concerns that arise that are particular to advanced directives? But I know we're out of time, and I'm sure my fellow panelists might want to comment.
I just only going to say that the case that came up when we discussed it was if Granny had given advanced care directive and Granny now has Alzheimer's and you have to hold Granny down to give her MAID, is that then an ethical problem? and I'll let you think about that one. But that was the case that came up because it had been a case in the Netherlands.
I'll just reframe this as a comment as opposed to a question just because of time, but you know, while I see value in kind of the efficiency and equitable access to information around MAID that we're seeing in BC, I am resonating with kind of what Marjorie's saying about how being, you know, the most responsible physician and having had nuanced discussions with patients about informed consent and advanced care planning, that, you know, when there is kind of this universal access, that all of a sudden there really isn't provisions around who might be the best person to you know, to access in regards to information about the patient's wishes, having long-term relationships with the patients and diagnoses and underlying conditions, but also, you know, the part of the physician that wants to be, you know, part of those nuanced discussions with patients and provide meaning and provide context and help a patient in an informed way come to a decision, you know, on their own about what might the options be. And so what I find, like, similarly is that, you know, like a surgical oncologist who might have had a single encounter with the patient might be asked about a diagnosis, but a palliative physician who has had like a 2-year relationship with the patient might not be even informed that you know, that the process has been initiated, or you get informed at completion of you know, of a request that your patient has requested this service. And so I think that's a really interesting place to be as a physician, just in terms of you know, our ethical moral responsibility, and also our own, like, provider satisfaction in providing care in the palliative realm. So
I think it's interprofessional respect of our different roles, and we have to really encourage that.
Okay, well, thank you very much. I think this was excellent. Thanks to all of you guys.